What is GDPR? And more importantly, how does it impact you and your company? Join internationally known data privacy, data protection expert Jonathan Armstrong and Tom Fox, the compliance evangelist, to learn more about the burgeoning world of data privacy and data protection. After listening to this episode, you'll walk away with a greater understanding of what this means for you and your organization. Life with GDPR is a production of the Compliance Podcast Network.
In this special episode of Life with GDPR, Jonathan Armstrong and I explore the recent decision by the UK Supreme Court regarding KBR documents sought by the Serious Fraud Office and the ruling by the court favoring KBR. Today we have Jonathan Armstrong from an undisclosed location somewhere in the United Kingdom, allegedly.
Yeah, one of the most interesting cases I think we've had across our desk in the last week or so has been the success for KBR in its fight with the Serious Fraud Office. And this concerns something called Section 2 notices, which many of us have been troubled by for some time. And effectively, they're a way of the Serious Fraud Office serving a notice on somebody to demand that they deliver up documents, and there's a criminal penalty if they don't. And they have been used controversially in the ENRC case when it has been alleged that they were used to sort of circumvent privilege and to obtain documents to which the SFO wouldn't ordinarily be entitled. And this case is a sort of part of the SFO's long-running investigation into Unit Oil, a Monaco-based entity. And you might remember that we talked about this before, particularly about the convictions that the SFO managed to obtain in a COVID-safe trial last year and those convictions. But effectively what happened here is that in April 2017, the SFO served Section 2 notices on KBR's UK subsidiary, Kellogg Brown and Root Limited. We'll call that KBR UK for ease. And KBR UK said, I'm simplifying, here are some documents, but there are another set of documents that our US parent has in their custody and possession, and you'll have to ask them for those documents. And so the SFO engaged in communications with KBR US, and there came a time when KBR US were invited in to chat things through at the SFO's HQ in London. The SFO made it clear that they didn't want that just to be a lawyer-to-lawyer or prosecutor-to-lawyer meeting, that they wanted representatives from KBR US in the room. And the Chief Compliance Officer and General Counsel came over the Atlantic to London. There was a meeting when the General Counsel was asked if she would hand the documents over, and it seems that she said that she would go back to the US and talk it through with colleagues and let the SFO know the decision, at which time a notice was served on her in the room under Section 2 on criminal penalty, effectively saying, well, you don't have the luxury of going back and thinking about it. We're going to serve the notice on you right here, right now. And the evidence seemed to be that the SFO had at least had this as a plan at the very latest at the time the meeting started. The evidence seemed to be that there was a draft notice that already existed, and the General Counsel's name was added to that when it was handed to her. And I think the case is troubling because there is at least a suspicion that the meeting was in part engineered to get somebody within the jurisdiction to serve them with a notice. And Tom, you and I both know Barry V2, one of the lawyers involved in this case, and I think that many people are potentially troubled by what could have gone on in that case. And the Section 2 notice, there was an agreed extension, and then KBR US challenged it, and they said, first of all, that Section 2 notices didn't have extraterritorial effect, and they also argued that it wasn't properly served. And it went to the divisional court, which is a sort of high court on steroids. You have to have two judges sitting, and the divisional court broadly agreed with the SFO, so it went up to the Supreme Court, who handed their judgment down on February 5th. And effectively, they just looked at one aspect of the case. They didn't look at whether the service was proper, et cetera, et cetera. They looked at whether Section 2 notices did have extraterritorial effect, and they said that they didn't. And effectively, because there wasn't enough connection from KBR US with the UK jurisdiction. Now, what the Supreme Court made clear is that this is a relatively rare case. As you'll remember, the UK bribery legislation does have extraterritorial effect. So if you're a US corporation with a UK subsidiary, then the UK subsidiary is subject to the Bribery Act. If there's an act of bribery where it's alleged UK nationals are involved, then the Bribery Act still applies. And if the act of bribery takes place on UK soil, so for example, if there had been meetings at Heathrow with KBR US executives and Uniroyal executives in the same hotel room, then again the Bribery Act would have applied there. So the court isn't limiting the effects of the Bribery Act, it's limiting the operation of these somewhat draconian Section 2 notices and saying that you have to have more of a connection with the UK for the Section 2 notice to be served. And the Supreme Court have said that, of course, there are mutual legal assistance processes in place which could be used. So, for example, the SFO could have requested those documents or requested the assistance of the DOJ to obtain those documents. And it seemed that they hadn't done that. That may be, reading between the lines, because there was some sort of a ugly bun fight between the SFO and the US authorities over who was going to prosecute whom. The only other thing to say, I think, for completeness is, of course, that the UK has altered its legislation since 2017 when these Section 2 notices were served. There is a new power that the SFO has now, catchily called the Crime (open brackets) Overseas Production Orders (close brackets) Act 2019, which in similar circumstances could allow the SFO to serve an order because there's some bilateral arrangements between the UK and the US. But those the provisions under the 2019 Act are harder to set up, and they could be subject to challenge. So in some respects, it's a loss for the SFO, and in some respects, their wings have been clipped, certainly in their use of these Section 2 notices, and it might be that they have to go through more established channels in cases like this in future.
Jonathan, the manner in which the SFO delivered the Section 2 notice requesting KBR to bring U.S. personnel to the United Kingdom for a meeting and then laying that on them, saying you now have jurisdiction, seems to me, I was offended by that. And I was wondering, do you think that fact had any influence on the UK courts, or they really focused strictly on the legal issues in front of them?
I don't know is the honest answer, but it's a long-standing principle of in the UK. We have this saying, he who comes to equity must come with clean hands. And this is legal jurisdiction, not equitable jurisdiction, and we could have a legal history lesson on how they are different. But I think what it does illustrate is that there's this overriding sense of fairness, I think, amongst judges in the Supreme Court particularly. And I think if it is true that the SFO were not transparent with the two representatives who came over from the US, I mean, they obviously didn't think they were coming over for high tea, buns and a brew. They obviously knew that they were coming over to talk about a serious case. But I'm not sure that the SFO were transparent about what the consequences might be of any failure to accede to a request. And I think that probably has influenced the judges in this case. Prosecutors have to behave fairly, and that applies to your jobbing prosecutor dealing with shoplifting and theft offences, and it applies the same, if not more so, to those dealing with the most serious offences which can deprive people of their liberty. So we ought to have that sense of fairness in mind, and I suspect the prosecutors will have that in mind more going forwards, and I think that's probably a message that the court here intended to give out.
This is Tom Fox again. I'd like to thank you for listening to this episode with Jonathan Armstrong on Life with GDPR. You can reach Jonathan at Courtier Compliance in London. Email me at tfox@tfoxlaw.com. Check out the show notes for more information on the KBR decision from the Courtier website and for information on GDPR compliance generally. I hope you will join us again for another episode as Jonathan and I start a 3-part series on some early significant enforcement actions and information regarding GDPR. Thanks so much for listening.